Dear ladies and gentlemen, today please watch, listen and read about the press release regarding the rule of law scandal in Switzerland. The press release was sent to the federal councillors as well as to the media representatives before Christmas last year. As explained in the press release, Dr. Gerard Saladin rejects a reasonable as well as feasible solution to end up this case. Ending up this case would also mean to limit the damage for Switzerland regarding the rule of law scandal. Because of his unacceptable decision and rejection of a reasonable solution, I demand Mr. Saladin's removal from his position and his dismissal as an employee at the Swiss Federal Administration. In such a situation, the superiors have to take over with responsibility, integrity, and moral. The federal councillors, especially Councillor Martin Pfister, chief of the DDPS, have to take over and enable this possible reasonable solution immediately, for us and for Switzerland. To begin with, I would like to show some parts of the preliminary information. Introductory remarks to the press release, overview of the rule of law scandal in Switzerland. Fact check, evidence, documentation. The statements contained in this press release are comprehensively substantiated by several hundred original documents, confirmations, official Swiss press releases, requests, petitions, lawsuits, criminal complaints, court documents, as well as images and videos. Last section. We can easily and clearly provide fact-checking for the contents set out in this press release and far beyond. Overview of the rule of law scandal in Switzerland. The rule of law scandal began with the abusive procurement practices starting in 2015 and the publication of the VBS Sport app Ready, involving significant violations of competition law and defrauding of the startup Perform Fun Ltd in spring 2019. Over the past more than 6 years, the Swiss Confederation has destroyed the startup Perform Fun Ltd and the economic livelihood of the startup entrepreneurs Daniel Sulzer and Andreas Sulzer. The Federal Department of Defense, Civil Protection and Sport, DDPS, VBS, its head of legal affairs, Dr. Gerard Saladin, and the head of department, Federal Counsel Martin Pfister, are refusing to pursue a reasonable solution and to bring this matter to an end. The Federal Council looks on and remains silent. This includes, in particular, the destruction of the startup Perform Fun Ltd by the Swiss Confederation, combined with the inability to resolve the matter by the former Federal Councillor Viola Amherd and the DDPS. Violation of WTO procurement rules in the acquisition of the VBS Sports app Ready. Active deception of the startup by the Department of Defense DDPS. Copying of the sports concept and innovation of the startup Perform Fun Ltd, now bankrupt by the Swiss Army and the Federal Office of Sport, BASPO. Significant violations of competition law in connection with the market launch of the VBS Sport app Ready in spring 2019. Fraud committed against the startup and the entrepreneurs by the Swiss Confederation, resulting in total damages of approximately 15 million Swiss francs by 2021. Political court proceedings and court rulings involving serious violations of legal and criminal law norms, as well as the Swiss Federal Constitution in all business-related and private matters of the entrepreneurs. The creation of an extensive structure of falsehoods, web of lies, under the leadership of Federal Councillor Viola Amherd, including fabricated fact by members of the Swiss Army, BASPO, the DDPS General Secretariat, and the Federal Department of Finance, FDF, submitted to the Federal Supreme Court in the case brought by the startup and Daniel Sulzer against Federal Councillor Viola Amherd and other individuals on 7 June 2021. The forced and coordinated enforcement of unconstitutional court proceedings against the entrepreneurs by judicial authorities and private beneficiaries of the Swiss Confederation. Arbitrary, unconstitutional and criminal proceedings as well as political decisions by Swiss courts. Delays by the Office of the Attorney General of Switzerland in handling the criminal complaints filed by Daniel Sulzer on 20th March 2023 against senior Swiss officials and their collaborators. Refusal to prosecute by the Office of the Attorney General, thereby enabling continued harm to the entrepreneurs, including unconstitutional enforcement measures against Daniel Sulzer, euro 250,000, and Andrea Sulzer, euro 18,000, as well as the concealment of the causes of the startup bankruptcy through a failed asset confirmation issued by peck's Occupational Pension Fund, and the abusive reopening of the bankruptcy proceedings of the startup Perform Fund Ltd. All proceedings were enforced abusively and with serious violations of legal norms and grave criminal law provisions. The causing and toleration of massive harassment and decomposition measures by the Swiss Confederation against the entrepreneurial couple for more than 6 years, both in Switzerland and at their new place of residence in Lübeck, Germany, including damage to business operations, hacking, espionage of business information and data, manipulation of communication systems and communications, obstruction of communication, deception through the insertion of failed persons into telephone conversations, manipulation of business contacts and individuals, defamation, including the sabotage and destruction of 2 additional companies. Deletion of data records and data files from PCs and storage devices, including the penetration of the professional Cisco Meraki firewall of Deutsche Telekom. Open, exhibitionistic and covert surveillance, wiretapping and monitoring of private and business premises via TV set, PCs, mobile devices, etc. Hacking of digital systems and devices, and the implantation of malware. Repeated trespassing, indicated with objects as well as allegedly secretly. Threats of violence, coercion, stalking, and acceptance of harm to life and limb. Social isolation and manipulation of the entrepreneur's social environment. Infliction of property damage. Filtering and blocking of email communications, extensive blocking of the IP addresses of the business and private computers of Daniel Sulzer and Andrea Sulzer in Switzerland. Prevention and delay of private and business mail deliveries, obstruction and prevention of registered mail by Swiss Customs and Swiss Post. Current situation. The obstruction of a reasonable political solution by the DDPS. The DDPS is the originator of this scandalous affair. The DDPS and senior Swiss officials are aware of the misconduct and crimes. The new head of the DDPS, Federal Councillor Martin Pfister, and his DDPS General Secretariat, in particular the head of legal affairs, Dr. Jur Gerhard Saladin, are fully informed about the unconstitutional and unlawful activities. They are aware of the serious violations and crimes within their own department and across the Swiss Confederation relating to the procurement and launch of the VBS DDPS Sport App Ready, as well as the destruction of the economic livelihood of the entrepreneurs Daniel Sulzer and Andrea Sulzer. They are specifically aware of the abusive procurement of the VBS Sport App Ready between 2015 and 2019, The highly anti-competitive market launch of the VPS Sport app ready in spring 2019. The refusal to provide a solution and the subsequent fraud committed by the Federal Council Viola Amherd and the Swiss Confederation at the expenses of the startup Perform Fund Ltd, its entrepreneurs and its shareholders. The abusive, criminally motivated and politically driven obstruction of the conviction of Federal Council Viola Amherd and other senior Swiss officials by the Federal Supreme Court in the case filed by the startup entrepreneur Daniel Sulzer and Perform Fund Ltd on 7th June 2021. The destruction of the startup Perform Fund Ltd, supported and enabled by Switzerland from 2019 until 2022. The destruction of the livelihood of the entrepreneurial couple Daniel Sulzer and Andrea Sulzer over the past more than 6 years through citizen-hostile, clearly nationalist and inhuman harassment and decomposition destruction measures, reminiscent of the ways people were persecuted a century ago. The delays by the Office of the Attorney General in Bern regarding the criminal complaint submitted by Daniel Sulzer on 20th March 2023 and the refusal to prosecute the government members, federal judges, federal and state employees, military personnel, private individuals, and employees of PEC's Occupational Pension Fund, BAL. The obstruction of prosecution by the Office of the Attorney General itself regarding abuse of office, acceptance and granting of advantages, deliberate delays, etc., facilitated by a law firm paid by the Swiss Confederation or by the extraordinarily rapidly appointed federal prosecutor Livio Stocker. The Federal Council and the Swiss Parliament are also fully informed of these ongoing, persistent, unconstitutional and intolerable developments since the publication of the VPS Sport app in spring 2019. Who holds authority in the DDPS and the Federal Council? Despite this, the head of the DDPS, Federal Councillor Martin Pfister, is currently evading responsibility, even though he publicly declared during his Federal Council election in spring 2025, "I will clean up wherever there is something to clean up," and he said, free translation. He is pushing the problem which originally arose within the DDPS regarding the abusive procurement and market launch of the VBS Sport app ready in front of him rather than addressing it. He acts in a manner equally to his predecessor, Federal Councillor Viola Amherd, who resigned because she was unable to handle the challenges. Federal Councillor Martin Pfister delegates this problematic matter to his head of legal affairs, Dr. Jürg Saladin. The DDPS head himself has not commented publicly on the issue to date. Obstruction of a feasible political solution. In May 2025, Daniel Sulzer submitted a practical political solution to Federal Councillor Martin Pfister. This solution, which is fully feasible, was obstructed by Dr. Jürg Saladin. The proposed resolution primarily involves compensation of 3.8 million Swiss francs for the damage suffered by Daniel Sulzer, which has meanwhile grown to over 10 million Swiss francs, excluding losses of the bankrupt company, other shareholders and creditors. Dr. Jürg Saladin justified his refusal to pursue the solution on 22 April 2025 by referring to a prior rejection by himself and Secretary General Tony Eder on behalf of Federal Councillor Viola Amherd, dated 14 September 2022. In doing so, he again misrepresents the facts, claiming that it is too late for an amicable solution. From the beginning, Daniel Sulzer consistently sought solution with the DDPS the Federal Council and Swiss federal institutions, even before the abusive release of the VBS board tab in spring 2019, and at every step to assert his rights. Examples include filing the compensation and satisfaction request with the Federal Department of Finance, EFD, the lawsuit against Federal Councillor Viola Amherd of 7th June 2021, the criminal complaints submitted to the Office of the Attorney General. Furthermore, the Federal Councillor himself had previously directed Daniel Sulzer to pursue legal avenues via a letter dated 31st January 2020, after Sulzer had once again requested a resolution from the Federal Council on 23rd December 2019. Implicit admission of liability. Dr. Gerard Saladin's refusal to implement the solution also constitutes an implicit acknowledgement of liability. Otherwise, he would not have to refer to the possibility of an amicable settlement at all. A crow does not peck out the eye of another. Ducks don't eat ducks. Dr. Gerard Saladin already served in the General Secretariat under the former DDPS head Viola Amherd, among others, together with the Secretary General Tony Eder and other Secretariat staff, such as the Deputy Head of Legal Affairs, Adrian Gassman. They and other administrative staff from the EFD and the Army leadership are also the creators of an incredible web of lies for the Federal Supreme Court in the case of the lawsuit by Daniel Sulzer and Perform Fund Ltd. Against Federal Councillor Viola Amherd and other high-ranking Swiss officials, dated June 7, 2021. In December 2021 and March 2022, the federal judges prevented a lawful conviction against the accused individuals and the compensation payment to Daniel Sulzer and the startup Perform Fund Ltd., totaling around 15 million Swiss francs for offences and crimes. The Federal Supreme Court should have fully upheld the state liability claim against the DDPS and the Swiss Confederation, which would have resulted that Federal Councillor Viola Amherd would have borne the main burden. On the one hand, due to the material facts, such as the significant disregard of legal norms in the procurement and market launch of the VBS Board Ready, including active deception, violations of competition. Also, due to an existing Federal Supreme Court decision regarding prohibited cross-subsidization and creation of uneven playing fields, as well as due to fraud, and, on the other hand, due to the significant procedural incapacity of the Swiss authorities, among other things, through the edifice of lies and fact creation uncovered by the plaintiffs, as well as due to the significant violation of the principle of good faith. That is, due to abuse of office, power, acceptance and granting of advantages, corruption, etc. The Swiss rule of law has failed. Even after all this, the entrepreneurs are of no value to Swiss institutions, the federal administration, or the Federal Council. They act and decide irresponsibly, without reflection on governmental and administrative abuses, without moral consideration, and in a manner hostile to citizens. The Swiss rule of law has clearly failed at all levels of the courts and at the Swiss Office of the Attorney General. The events, the true facts, and the evidence from countless documents are highly incriminating for the Swiss Confederation. These include documents relating to the publication of the VBS Board Ready, numerous emails from the Swiss Army and the DDPS, from those responsible for the damage, and from the highest level of leadership. Internal file notes deliberately constructed for this matter by the DDPS BASPO, personal letters from Federal Councillor Viola Amherd, from the Chief of the Army, CDA, Lieutenant General Philippe Rebord, and from BASPO Director Mathias Remund, fails and incomplete Army minutes from the joint meeting of 14 May 2019, an extensively uncovered edifice of lies, inactivity, omissions, revision requests ignored by the courts, complaints and applications for legal aid, highly arbitrary court judgments, correction orders drafted retroactively, and rulings issued without consideration of facts, apparent fabrication of facts, lies, and refusal to acknowledge the true circumstances, etc. Swiss procedural authorities, judges, and court clerks completely denied the applicants and plaintiffs their rights. Dr. Saladin's obstruction of a feasible and reasonable solution involving a discussion and an agreement with the entrepreneurial couple, Sulzer's wife, Andrea Sulzer, has long since been a victim of the abusive Swiss practice, is carried out with full knowledge of the above violations and crimes by the Swiss Army, the Federal Office of Sport, BASPO, the DDPS, the FDF, and the Swiss Confederation as a whole, as well as with knowledge of the citizen-hostile actions against the couple. This lie and the prevention of a reasonable solution sent Daniel Sulzer, 62, and Andrea Sulzer, 61, directly into the final destruction of their existence. Switzerland has destroyed their assets and their fruits of over 45 years of work, including the startup assets together with their investment and labor, a semi-detached house, also intended for the social security of a family member, other businesses, inheritance shares from deceased parents, and finally their retirement savings necessary for survival. The little that has not been destroyed by the Confederation will now have to be sold on an ongoing basis, which is already the case. At the same time, up to the present day, spying, surveillance, and hacking of digital systems, such as PCs, including LinkedIn and similar platforms, continues. Absolute control and destruction appears to be Switzerland's sole objective. Official Switzerland does not comment. The return receipt cards from the federal councillors concerning the registered letters sent to them with the various requests for solutions and justifications dated 20th October 2025 arrived today, on 18th December 2025, after 59 days. And precisely one day after this article was written on the hacked computer, in the first version of the article, the complete absence of return receipt cards was noted. The return receipt cards from the head of the DDPS have still not arrived. Swiss Post and Swiss Customs demonstrably delay registered shipment to the Federal Council, as occurred at the beginning of this December, not for the first time. The shipment was only forwarded during customs transfer after Daniel Sulzer pointed out consequences to Swiss customs and the Swiss Confederation. Means of silencing the inconvenient entrepreneurs. As mentioned, Dr. Gerhard Saladin is fully aware of this unconstitutional situation. He uses the executive power assigned to him as head of legal affairs at the DDPS by once again resorting to an obvious lie and the pretextual argument that there is a federal Supreme Court ruling in the matter, lawsuit of 7th June 2021. With complacency, he excludes from consideration the inactive, non-rule of law conduct and omissions of the Office of the Attorney General, as well as the refusal to prosecute, including those reported federal judges who ruled abusively in the matter. In this respect, it cheaply refers to the long since non-existent separation of powers. The head of legal affairs at the DDPS acts deliberately in a citizen-hostile, nationalist and autocratic manner. He functions as an enforcer for his own kind in order to silence the people defrauded by the DDPS and the Swiss Confederation through the destruction of their existence or to remove them, at least Daniel Sulzer, entirely from the public sphere. Life-threatening ship manipulations, attempts to attribute psychological damage to Daniel Sulzer or to provoke him into criminal acts as part of the harassment and decomposition measures. In the evenings, after dark, Daniel Sulzer can neither walk alone through a Christmas market nor carry out his regular jogging within or outside Lübeck. The Federal Council and the Swiss Parliament appear to find the destruction of the existence of Daniel Sulzer and Andreas Sulzer more than acceptable. In particular, former Federal Counsel Viola Amherd, who in this matter decided in favor of criminal conduct for herself and parts of her environment. With her incitement shortly after assuming office in 2019, she increasingly involved both federal and private individuals in the affair. She was supported in her actions and omissions by the Swiss People's Party, SVP, and private helpers, as can be observed throughout the entire course of the affair. Beginning with the initial web of lies and the falsification of Army documents by Training Commander Lieutenant General Daniel Baumgartner and his minutes taker Dr. Mark Megwiller. The leadership role of the Federal Councillor is evident from internal documents, and the Federal Councillor's refusal to pursue a solution. Continuing through the massive web of lies created by the legal staff of the Federal Department of Finance, FDF, Simon Müller and Dr. Raphael Kramer, and DDPS staff members Tony Eder, Adrian Gassman, Martin Rindlisbacher, etc. Likewise, with the knowledge and under the leadership of the then Federal Councillor, Federal President, Uli Maurer, and others. Up to the federal judges and court presidents, including Hans-Georg Seiler, who stepped down at the end of December 2021. He is responsible for a correction order issue at year's end, prior to his unannounced and surprising retirement for the plaintiffs, backdated, forgery of documents, as well as for his active deception regarding a non-existent counterclaim by the Swiss Confederation, and for violations of relevant legal norms and the federal constitution, as well as his successor, Florence Aubry-Girardin, who advanced her career directly through his matter and was appointed president at the Federal Supreme Court. She dispensed with a decision on the merits and the facts of the case and arbitrarily and omnipotently, not subject to appeal, declared the lawsuit invalid after 9 months, sweeping it under the carpet. She declared that clarification of whether Daniel Sulzer was entitled to free legal assistance was no longer necessary following her denial of justice toward the plaintiffs. The financial circumstances and the fact that Daniel Sulzer had been legally excluded by previous office holders would have made legal representation mandatory under the law. The reference by the head of legal affairs at the DDPS, Dr. Gerhard Saladin, to this abusive Federal Supreme Court ruling in his obstruction of a solution clearly demonstrates his intention to bring about the final destruction of the entrepreneur's existence and thus his citizen-hostile, irresponsible, and immoral conduct. The current, still Federal President Karin Keller-Sutter, Federal Councillor Albert Rösti, and former Federal Councillor Uli Maurer, as well as the Swiss People's Party SVP, which bears central responsibility through its judges for a departure from the rule of law, also in relation to another submatter, namely the forced enforcement by the federal-affiliated RHW Foundation from Treason, Liechtenstein, against Daniel Sulzer in excess of euro 250,000, are the direct beneficiaries of the destruction of the existence of Daniel Sulzer and Andrea Sulzer. As mentioned, these government officials, together with other federal, state and private individuals, have been reported by Daniel Sulzer to the Swiss Office of the Attorney General by criminal complaints since 20th March 2023, without these complaints being taken up by the Office of the Attorney General, as also mentioned above. Cf. above, reference to the separation of powers by Dr. Gerard Saladin. The entrepreneurs have comprehensively and clearly presented the federal offences and crimes to the courts and to the Office of the Attorney General. The senior Swiss officials do not wish to inform the public about this scandalous and citizen-hostile affair. They prefer to eliminate these devastating events outside the rule of law and to destroy the entrepreneurs. There is no justification for the Swiss Confederation's actions against the entrepreneurs. Daniel Sulzer and Andrea Sulzer had also founded the startup Perform1 Ltd. In order to build an international company in the digital sector in Switzerland. This began already in 2010 under the former name Fixport Ltd. Apps were very rare at that time. In addition to the entrepreneurs, other family members, including young, equally committed people, invested in this project and actively contributed personally with enthusiasm, also for Switzerland. The family has been strongly committed to Switzerland, creating innovations and added value for society through an above-average number of military service days, education and training, and personal engagement. Through the incredible, unconstitutional, citizen-hostile, nationalist, and still completely destructive actions, compare the behavior of the head of the legal affairs at the DDPS, Dr. Gerard Saladin, the head of the DDPS Federal Counsel, Martin Pfister, and the silent Federal Counsel, the Swiss Confederation has materially and ideologically significantly defrauded the family of Daniel Sulzer and Andrea Sulzer. Only an immediate political solution can enable a rule of law compensation for the economic damage inflicted on the entrepreneurs and their family. The dependencies between Swiss judiciary members, judges, prosecutors, case officers, etc., and their political promoters, parties, SVP, parliament, etc., are too great regarding this matter. The procedures and behavior of the Swiss authorities makes this very clear. Numerous documents showing the dependent structures, such as the exposed DDPS and FTF Web of Lies, the immediate withdrawal of the FTF legal staff statement after the exposure of a non-existent counterclaim by the Confederation, the transition of the federal court presidents, the subsequent correction orders in the different courts, the coordination among DDPS note writers, the refusal to correct protocols along with the personal behavior during the meeting at the Swiss Army Training Command on May 14, 2019, the created and documented false narratives, the various contradictions in the proceedings and federal documents due to the false cover-ups, the contradictory mail processes, etc. The matter can now only be reasonably resolved for the entrepreneurs through a political solution. The lost time resulting from the corrosive measures, the effort required to maintain a somewhat functional life of over 6 years must be accepted by them regardless. Extended topic overview. The fraud against the startup performed van Ltd by Switzerland with the procurement of the VPS Sport App Ready and the abusive cover-up under the leadership of the former DDPS head Viola Amherd. The new head of the Federal Department of Defense, DDPS, Federal Counsellor Martin Pfister, and his head of legal affairs at DDPS seamlessly continue the fraud, which has long been ongoing under the Confederation. The VBS and Switzerland are entangled in lies. They have defrauded the startup and its stakeholders. At the latest, with the market launch of the VBS Sport App Ready on March 4, 2019, and the subsequent refusal of a compensation solution for Perform Van Ltd, the Confederation defrauded the startup, the entrepreneurs, the former shareholders, and the creditors. Perform Van Ltd developed between 2013 and 2016 the foundations, concepts, and first application of a fully fledged coaching app for sports, fitness, and health. In the following years, the startup and its Perform Van app were established, expanded, and developed with private investments. Daniel Sulzer, CEO of Perform Van Ltd, contacted in April 2015 the then Chief of the Army, CDA, Corps Commander Dominique Audry, to explore a potential collaboration with the Swiss Army. The startup's innovative sports concept enabled independent, individualized, and correct learning, as well as guided learning on the digital sports coaching, also for military purpose. At the time, this concept was unprecedented. No solution existed in the market that allowed individualized, self-directed, scientifically based promotion of personal fitness and sports with full coaching functionality for different performance levels, covering various topics and programs with complete workouts, visual, audiovisual, and animated guidance, as well as individual evaluations for the user. On July 13, 2015, Colonel IG René Allman informed Daniel Sulzer after internal assessments that the Swiss Army might potentially have a need of the area of sports soldier training and Army sports education. They are currently in the concept phase and will be ready by the end of the year to familiarize themselves with the startup's tool. His superior in planning, Captain Stöckli, scheduled a meeting with Daniel Sulzer on November 11, 2015 at the Federal Sports and Competence Center in Macklingen. Although the contract for the VPS Sport App had already been awarded in October 2015 to a third company, without a formal requirement profile, according to the confirmation of the Chief of Training, Swiss Army, CMAP number 124317, about which the startup was not informed. The Army and the BASPA representatives, led by Colonel IG René Allman, held the agreed meeting with Daniel Sulzer on November 11, 2015, were informed about the concept and promised him pilot projects. Switzerland, as a WTO member, significantly violated procurement rules and actively deceived Daniel Sulzer and the startup. The startup released its first version of the Perform Van app in October 2016, followed by continuous updates. The Army confirmed that their VBS Sport App Ready was developed within 4 months in 2017. Among other things, this time frame is far too short to create a fundamentally new concept of the type developed by Perform Van Ltd. A comparison of the apps clearly shows that the VBS Sport App Ready copied the startup sports concept, including graphical details. The Swiss Army and BASPO copied the startup innovation. They launched the VBS Sport App Ready on March 4, 2019, presenting it to the Swiss population with significant competitive violations. The Army and BASPO claimed the unique features and innovation of Perform Fund Ltd as their own, even though these had long been publicly available through the Perform Fund app. The DDPS VBS provided the Army-founded sports app free of charge to the civilian population, also violating the federal court-confirmed rules prohibiting cross-subsidization and creating unequal playing fields. Despite contact by CEO Daniel Sulzer with the then Chief of Training of the Swiss Army, Corps Commander Daniel Baumgartner, and the Swiss Federal Council in summer 2018, the DDPS allowed the competitive violations and fraud with its VBS sports app ready from March 2019. With significant competitive violations, actively promoting the VBS sports app ready as an innovation and using the unique features of Perform Fund Ltd, the Perform Fund app, along with extensive media presence across all Swiss formats, TV, news, internet, magazines, daily newspapers, etc. The Confederation effectively pushed the startup out of the market. The value of the privately financed startups' shares collapsed completely, and new investments no longer materialized. The Federal Council and Parliament have been aware of this unlawful matter since 2018-2019. VBS head Viola Amherd was informed of the facts at the latest by a letter dated March 11, 2019. A reasonable solution at that time could have saved the startup, and the Federal Councillor was aware of this. However, Viola Amherd never allowed a solution to this disaster inflicted on the startup. On the contrary, a solution meeting proposed by Daniel Sulzer took place on May 14, 2019 at the Training Command site in Bern. The Army then falsely claimed that it had suggested the meeting. In the largely prepared protocol of the meeting, which was supposed to be signed by both parties, only the Chief of Training, Corps Commander Daniel Baumgartner, and his recorder, Dr. Jur Mark Wegmüller, signed. The protocol mainly contains the false narrative from Daniel Baumgartner's letter of September 19, 2018, as presented by the training commander to Daniel Sulzer. It did not document the essential information from the startup, such as the app comparison showing the copied sports concept with graphical details, nor the offer of 240,000 Swiss francs by Corps Commander Daniel Baumgartner to the startup, Daniel Sulzer. Internal notes, such as the note from the Head of Legal Application and International Law DDPS, Deputy Head of Legal, Adrian Gassman, titled misleadingly Fact Sheet. An email from Training Commander Corps Commander Daniel Baumgartner, and other documents created and apparently coordinated by VBS BASPO to cover up the matter, show that Federal Councillor Viola Amherd took the lead in covering up the fraud and destroying the startup from the very beginning. The Army and BASPO spied on the startup, actively deceived it, and copied its innovation. The DDPS and the Confederation ultimately defrauded and destroyed the startup. Nothing must remain. With the failed claim of a new asset of 8,935.4 Swiss francs in favor of the startup from its former pension fund PAX, Occupational Pension, BAL, the Höfi Canton of Schwyz Bankruptcy Office, led by Bankruptcy Officer Cornelia Imholz, reopened the bankruptcy proceedings of the startup in autumn 2024. The bankruptcy of Perform Fund Ltd had already been completed in January 2023. She did this despite clear notification of the failed asset statement. PAX refused to correct its documented error. As part of the reopening of the bankruptcy, the documented reasons for the collapse of Perform Fund Ltd, namely the fault of Federal Councillor Viola Amherd and the Confederation, were irrevocably erased from the records. Case eliminated and closed. Today, after more than 6 years, during which the DDPS and the Confederation used unlawful and politically motivated court rulings to erase their offences and crimes and to eliminate the economic basis of entrepreneurs Daniel Sulzer and Andreas Sulzer, the new head of the DDPS, Federal Councillor Martin Pfister, and his Chief of Legal Affairs, Dr. Gerard Saladin, pick up exactly where former Federal Councillor Viola Amherd began, continuing the lies and fraud against the startup and its stakeholders. They aim to wipe out the matter along with the defrauded entrepreneurs, supported increasingly by the parliamentary majority, the SVP, the entire parliament, and the Federal Council. Daniel Sulzer is convinced that the Confederation, the government, the federal administration, and politics will gain nothing without a reasonable solution for the entrepreneurs. Partial matters. Further violations of the rule of law by Switzerland against the entrepreneurs. Swiss Federal Prosecutor's Office failing to fulfill its duties, clearly coordinated and orchestrated. The dismissal of the criminal complaints against the Federal Prosecutor's Office itself, carried out by the urgently appointed extraordinary Federal Prosecutor Livio Stocker, occurs without considering the substantial facts and circumstances submitted to the Federal Prosecutor's Office. These facts clearly demonstrate the delay of the criminal complaints, the granting and acceptance of advantages, corruption, and the violations of legal norms, e.g., the mandatory enforcement of criminal proceedings. The Federal Prosecutor's Office remains silent to this day. The significant, documented, and highly incriminating criminal complaints against high-ranking Swiss officials, federal and state employees, and private individuals are being left unaddressed. Whether these complaints will even be processed at all, given the referencing, abusive, and federally founded order from the extraordinary Federal Prosecutor Livio Stocker, which refused to take action on the complaints against the Federal Prosecutor's Office itself, is questionable. This procedure constitutes and would constitute a further blatant violation of the applicable legal norms in the Swiss rule of law. Outstanding enforcement of over €250,000 against Daniel Sulzer, registration in the German debt registry Schufa. The Liechtenstein-based, federally affiliated RHW Foundation, with the purpose of assisted dying, initially provided 150,000 Swiss francs for the development of the Perform Fun app for an indefinite period. They pressured for repayment, including through a contract amendment. With the destruction of the startup, repayment became impossible. The RHW Foundation initiated enforcement proceedings against Daniel Sulzer through the Württemberg-Sarganserland District Court, Switzerland, case manager Hans Willi. The objection lawsuit filed by Daniel Sulzer, which clearly outlined the simple partnership entered into by the RHW Foundation with the startup, was dismissed by the courts and the case officials mentioned. The single judge of the Canton of St. Gallen, Dr. Caroline Kirchschläger, and the federal judges Thomas Wittmer, court clerk Christine Kiss, Monique Ermetti, and Yves Rüdi. Through grossly arbitrary and criminal orders, coercion, active deception, acceptance and granting of advantages, etc., and coordinated corrections of rulings, they approved the non-compliance with the RHW Foundation's deadline to respond to the objection lawsuit, as well as the equally granted extensions after the deadline by the district court case manager. Both actions violated relevant legal norms, which in the lawsuit against federal councillor Viola Amherd at the federal court were later confirmed, but to the detriment of Daniel Sulzer and the startup. Furthermore, Daniel Sulzer's request for free legal counsel was delayed. Despite meeting the required conditions for free legal counsel, it was not granted. Ultimately, the Werdenbergse Ganserland District Court conducted the show trial in the absence of Daniel Sulzer and without legal counsel for him. As expected in this partial matter, the court ruled against Daniel Sulzer. The entrepreneurs are forced back to Lübeck for further surveillance and control. The RHW Foundation initiated enforcement proceedings through the court in Lübeck 1 day before the entrepreneurs went to embark to their planned 4-month sea voyage on May 6, 2025. This was done to prevent them from escaping surveillance and control in Lübeck and, at the same time, to hinder the completion of a manuscript documenting the incredibly anti-citizen event. Despite the hidden travel plans outside the rented apartment, the RHW Foundation was aware of the departure. During the voyage, the entrepreneurs were further monitored at ports in Denmark and Sweden. They returned to Lübeck after only 9 weeks, after their ship was manipulated 3 times in ways that were life-threatening for the husband and wife crew, and after the new head of DDPS, Federal Counsel Martin Pfister, and his head of legal, Dr. Jürgen Saladin, blocked the solution through falsehood. Additionally, an international arrest warrant had been issued. The RHW Foundation had been informed against Daniel Sulzer, triggered by the enforcement order, should he fail to disclose his assets to the enforcement officer. Upon returning to Lübeck on July 7, 2025, the officer stated that he had no further orders. Daniel Sulzer is now registered in the German debt registry, Schufa, with approximately €250,000. The entrepreneur couple has been under continuous surveillance, monitoring, and digital hacking from the day after their return, and the RHW Foundation can enforce their seizure against Daniel Sulzer at any time. Enforcement against Andrea Sulzer with proven lie by the rogue liar, also initiated at the Werdenbergse Ganserland District Court. The former board member and close confidant of Daniel Sulzer, Dr. Paul Perot from Oegst am Albis, enforced the seizure against Daniel Sulzer's wife in the amount of €16,534.74 plus additional cost on October 16, 2024 in Lübeck. It is documented that he knowingly relied on a falsehood regarding a loan, which was never granted to Andrea Sulzer. The documents confirm this. The request that he retract his lie was ignored by the lawyer. The lawyer could count on the support of the case manager Hans Willi from the Werdenbergse Ganserland District Court. With the court order, without Andrea Sulzer participating in the proceedings, Dr. Paul Perot carried out the enforcement in Lübeck in October 2024. This occurred at the same time as the failed asset statement by peck's Occupational Pension Fund and the reopening of the bankruptcy proceedings, which erased the documented reasons for the insolvency of the startup Perform Fund Ltd. Final personal note. The official Swiss authorities openly allowed the destruction of the livelihoods of Daniel Sulzer and Andrea Sulzer, fully aware of the massive injustice inflicted upon them. They, the Federal Council and those in power, want to erase the wrongdoing and crimes occurring within their ranks and keep them hidden from the public. They, and in particular the head of the DDPS responsible in this matter, Federal Councillor Martin Pfister, allow their enforcer, the head of legal affairs, DDPS, Dr. Gerard Saladin, to act without oversight. So far, they have refrained from implementing a reasonable remedy for the damage caused to the entrepreneurs by the Swiss Confederation. Yet, a fair and reasonable solution would be easily achievable for Switzerland. Daniel Sulzer.